All right, welcome back. It's another Hot Topic Tuesday. We are what, May 20th. Quick reminder for those that are the early birds, no hot topic next week. That way you guys can save yourself the time and keep right on working and talking to a lot of people. So today, I'm like, we'll see how many people actually turn out for it, because I'm giving what most would think is a fairly, we'll call it boring topic, or that I actually have all of it. I understand earnest money deposits completely, but I will share with you that there's a reason this is on here. And it's because in the past week, I've been entertained by brokers outside of our company, agents outside of our company. We'll call them our brokers and agents within our own company regarding earnest money deposits. So what we think may be real clear, I've discovered really hasn't been. So let's get it going. As long as this will work for me. Let me get the proper click here. There we go. So here's what I want to do. Give you a simple, clear understanding, regardless of the situation, of how earnest money deposits are handled. Why do we even hand them? Matter of fact, let's look at it this way. Here's what we'll cover. What's the MD for? How much should I get? Who's to hold it? Because this is an interesting one that comes up. How is it actually applied? I think almost everybody understands that. Here's one where it gets to be really tricky. What happens when there's a default, either by the buyer or the seller? What's the mutual release for? Why do we do it, and why do we do it the way that we do it? And matter of fact, how should we be doing it? And of course, what if there is a dispute over the earnest money deposit? That's what we're going to cover today. So what's it for? It's to show the buyer's good faith and their intent to perform to the terms of the purchase agreement. So if you sign a contract with me that as a seller, I know that you are going to close on this transaction as to the terms of the purchase agreement. If you were to walk away from it and get your earnest money deposit back, it's because of the terms of the purchase agreement. So here's a question for you. Is consideration, earnest money deposit, is it required by law? Now, I got a few of you on screen here. Shake a head. Okay, there. All right. The answer is no. And I gave you the quick one with that one because it popped up without me clicking the button. The earnest money deposit itself is not necessary to create a binding agreement. It could be love and other good consideration. So the aspect of having to have a, what do I want to say, earnest money deposit is not accurate. However, it is the best way for us to make sure that we're taking care of the parties to the transaction. Here's one that I want you to be careful of. It is a liquidated damage provision to the purchase agreement. There is a misunderstanding that this is all that it would ever cost a buyer to walk away. Let me hear it. I'm going to say it again. There is a misunderstanding that if I decided I didn't want to buy the house, I could simply forfeit my earnest money deposit and walk away. Not true. We'll talk about that in more detail. So how much should I get for an earnest money deposit? And you guys can share. I want you to pop it up. In this case, I'd like you to put it into the chat. What is the dollar amount that you should be getting for earnest money deposit? And I'm going to say, I don't think it really matters whether or not you're representing the buyer or seller in a transaction. What should we be looking for? This is group participation time. They're not doing very well, as you can see, Mary Ellen. And if not, maybe, okay, good. All right. How much can the buyer afford? That's a great answer, because if I'm doing, say, and I got a mortgage originator, loan officer with us today, How much can they afford? So if it's VA and they're getting 100% financing and they're getting a bunch of concessions toward closing costs, taxes, prepaids from the seller, how much money do they need out of pocket? So you may not get a whole lot of them, but yes, I'm going to say those are all great answers because we want to get as much as possible, is the way that I'm going to put it. Get as much as possible. And that's the abbreviation for it. Get as much as possible. Yet the 1% I think is the minimum. If you're collecting $500, yeah, it's probably not enough. Even, I mean, today's prices, even for the lowest ones, that's a pretty simple thing to be able to walk away from, which is typically all it would take. Get as much as possible is the best answer, but 1% in most cases is the minimum. I'm going to say even on the lowest price houses, 1,000 is the minimum, but 1%, minimum of 1,000. Okay. Why cap it at 3%? Kind of simple. What's the reason, Mary Ellen?
You don't need to cap it at 3%.
We could even go higher, but what might we cap it at that for? What's your compensation? So typically 3%, if we got 3% compensation, that would be really, really good. But we wouldn't have to worry about overage, and we'll talk about that in a bit. But when do we have to turn it in? Immediately. That is the company policy, and per Michigan license law, our rules, the code says when we as an agent receive it, we must turn it into the broker immediately. I'm going to look at faces down here for a second. This is where I got all the faces, guys. Turn it in immediately. That means if I get it today at noon, I should be making a trip to the office today, not tomorrow. If I get it at 3 o'clock on Friday, I should be making it to the office before 5 o'clock. Get it out of your hands so that you're no longer responsible for it. And that is company policy, and that is the law as to how we as salespeople must handle earnest money deposits. So, who holds it? Let's keep it simple. For the most part, if we receive it, we hold it. Now, we'll take a look at how our purchase agreement is written, but we're talking in general terms. Most purchase agreements are actually stating that the buyer is depositing blank dollars with the broker. We'll talk about that more in a second. So if the co-op broker received it, they should hold it. In any transaction, either broker can hold the earnest money deposit, but the key is that whoever is holding it, it needs to be stated on the purchase agreement. Most purchase agreements, and I haven't looked at all of them within our company, but most purchase agreements says the broker deposited with the broker, the buyer's depositing with the broker, and that would be the broker who's working with that buyer. All right. Now, it could go with the title company, and the title company will probably have an agreement as to how it would be held. But on the purchase agreement, it needs to be stated the title company is holding it. It could be that you're working on a new build. Builders love to hold the earnest money deposit. It's fine as long as all parties agree to it, but it must be stated on the purchase agreement that the builder is holding it. Okay? So again, that has to be done on the purchase agreement. And guys, if there's any issues, just apprise all parties to the situation. Sometimes a check bounces. Don't hold that secret. Okay? Get it taken care of. But keep everybody informed. Now, here's the other thing, and this is the biggie. My wife, who's, wow, she's been title mortgage. She works with me on our transaction. She said, make sure that everybody remembers this. You have to cross out the account number when you send copies of the earnest money deposit. If there's an agent who sends it to you and they haven't crossed it out, my recommendation is you cross it out. No need for you to receive it and somebody get that from you. Okay? Look, there's crooks in this world, whether you think it could happen to you or not. Preventative. Be preventative. All right? Redact, cross it out. And we'll talk more about why do we even receive copies as we move along through this. So when must we receive the EMD? And this is one of the big questions. I'll share with you that I was brought up in a situation where I'm talking with a couple of different brokers, and I can happily say this was outside of our company. And there was a discussion regarding when should the earnest money deposit be received. In a purchase agreement, and again, I want you to, as we're talking about this today, how does it work when you receive an earnest money deposit? Whether or not you're on the buyer side or the seller side, whether it's our purchase agreement or someone else's purchase agreement, what does it say? Many of them will say buyer is depositing with the broker blank dollars. Now, if it says that, let's interpret what that means. Mary Ellen, what do you think? I got Mary Ellen with me here. I just had her daydreaming a little bit. I caught her off guard. So buyer is depositing with broker $10,000. What is that saying? When do I have it?
They won't then unless it's written differently.
That's it. So Mary Ellen just nailed it. We have it unless if the purchase agreement states something different. Now, again, that's the way most are written. You should have received, and I'm going to tell you, get a copy of it, that they actually have it. Because many agents don't. I don't know how many don't. But I tell you, I was dumbfounded when I'm sitting here talking to 5 individuals who didn't understand what that verbiage said. So it said buyer is depositing, and there's nothing else being said other than an additional amount would be deposited by, but that initial deposit says they have it. So here's what I'm saying. Watch the timeline. And I'm going to say that if we're on that side of it, if we're representing the buyer, maybe it's within 5 days because our purchase agreement will address it. I'll put it up. But I'm going to tell you, don't do it or let's see, how will we, upon removal of inspection contingency. Here's the problem. You think, well, yeah, but I'm taking care of my buyer that way. Well, only, I mean, wait a minute, for what reason? Well, they're losing interest on it. Bunky, right? Come on. It's 4 weeks. Even if it's 8 weeks, how much are they really losing on an earnest money deposit? So wipe that excuse out. Here's the worst part. And don't go, well, it'll never happen to me. I always remember. Until it happens to you. Because it's so far out, when they finally remove it, you forget to collect it. And you think, oh, well, no problem. I'll just get it when I remember. Well, you got to remember first, but then, well, yeah, but even if I forget, we'll just do an addendum at the time of closing stating that we never collected it. Does that happen? Yes. Okay. And you think, so what's the problem, Darwin? The problem is when the buyer says, I don't want to buy the house. And they don't show up for closing. Now, who do you think is going to pay for that earnest money deposit to give to the seller because your buyer didn't sell or didn't show up, did not close, didn't live up to the terms of the purchase agreement. Gang, it's happened. It's happened to, at least one of my agents when I was managing. Just don't do it, guys. You got to remember to collect it. Okay. Here's what the purchase agreement says. Our purchase agreement. Buyer is depositing blank amount of dollars. Is depositing with, that's the escrow. Now, normally that's going to be either Coldwell Banker Professionals or Century 21 Professionals. But it could be the title company. That could be the builder, and you're going to list the name out on the purchase agreement, and you're going to put that it's in the dollar amount that you're getting, and it's in the form of a check, money order, cashier's check, certified funds wired directly to the broker. I will tell you in any future update, we'll change that. It will become escrowee because we just said that it could be with the other broker. It could be with a title company. Could be with a builder. Therefore, it's not money wired directly to the broker. EMD will be collected and deposited within blank calendar days of acceptance by the seller. And it doesn't say BUY on the purchase agreement. That's Darwin's typing error last night. Within blank calendar days of acceptance by the sellers. Okay? Now, how many days is that? I'm going to tell you that most sellers, most agents are going to like that as a shorter window. But this is written for a lot of different reasons. But here's the key. Remember to collect it. And as a courtesy measure, my book, courtesy measure, if I want copies, I think the listing agent that I'm doing a deal with deserves a copy that we actually have it. Okay? Send it over to them. And before I do, what do? I'm giving you the hint. Redact the account number. Cross it off. Obviously, once it's deposited, and I would say for our managers and brokers that are on here, make sure that the admins in our offices are doing the same thing. Right. So, how can EMD be dispersed? Well, here's the rest of what that paragraph says. We're going to treat it through the laws of the state of Michigan applied to the purchase price at closing. It can only be dispersed in accordance with either the terms hereof, otherwise we've met the terms of the purchase agreement, or we need a fully executed mutual release, or a civil action is determined to whom the deposit may or must be paid to. Okay? It's only those three things. So either we closed according to the terms of the purchase agreement, it was applied to the purchase price, we have a fully executed mutual agreement, or there was a court action that said, give it to these people this way. Now, that's keeping it simple, and everybody knows that's one of my MOs. KISS principle. I hope everybody's good with that. Here we go. So, when is it required for the broker to deposit the EMD? This is one of the most confusing part because everybody's heard 48 hours. But let me again, when do salespeople have to turn it in? Immediately, as per company policy and the state law governing how we handle earnest money deposits. And by the way, if there's anything that's ever going to get you in trouble with the state of Michigan and your license, it's mishandling other people's money. So get it to them immediately. When does the brokerage have to deposit it? So again, agent must turn it in immediately. The broker must deposit it. Now, you've got to hear the detail to this because it's really fun to throw this out to people who don't know it. Within 48 hours of receipt of the seller acceptance of the purchase agreement. Now, notice I didn't say within 48 hours of receipt of the earnest money deposit. So when the broker receives an earnest money deposit, the broker must deposit it within 48 hours of receipt of the seller's acceptance of the purchase agreement. So if you ever have one mailed to you, we should be holding on to the envelope and keeping it as part of the file. That's our evidence as to when we even received it. Because a buyer could have dated it for the date that they put it in the mail, and it took 5 days to get through the United States Postal Service. And we'd be 48 hours past because we have nothing to show when we actually received that deposit. But again, it's when we receive it, and when does it say? From the acceptance, receipt of acceptance, and of course, purchase agreement. Because if we said that we will deposit it within 5 days of, well, again, we have 48 hours from when we receive it. But if you put 5 days, then you need to have received it, and we as a brokerage need to have it deposited within 5 days. That's living up to the terms of the purchase agreement. Okay? Any questions about any of that so far? Because this is, again, one of the most confusing parts. I'm going to check. I got a question here, guys.
I got an offer and I asked for a copy of the receipt. Still don't have it.
Wow. So here's something that we run into. And I'm guessing that probably some of us don't even understand why we ask for those things. I'm on the listing side. I've accepted my buyers, or I should say my sellers have accepted a buyer's offer, and I request a copy of their earnest money deposit because it says you have it, or we've accepted it 5 days. We're expecting to receive a copy of it after 5 days. Either way, we requested it and we're having trouble getting it. We need to know why we want that. Okay. So from me, I'm the listing agent. It says that you have this money. If you're living up to the terms of the agreement, how do I know that that earnest money deposit is there? Show me a receipt. Give me a statement. But what's the easiest way? Show me a copy. It could be a copy of the statement that says that we received it because it was a wire. Okay? I want something to protect my seller so that the money is there in case anybody were to default. So why do I want that as a listing agent? I want to make sure that you are under the terms and not in default of the terms of the purchase agreement. Okay? That's why as a listing agent, we should be looking for that. Okay? And if they say they've got it, I told you the story of just a bit ago as to why. Because it wasn't collected. And I'll tell you that an agent was struggling to get a copy of it. And, oh, by the way, it was never deposited. And then, of course, you get to try to fight to get that. Let's see. I'm just checking my chat room here real quick, guys. So the first one I'm looking at here says, do you want it to say upon acceptance if we don't have a deal yet? I think it depends upon your strategy. Okay. Company doesn't have a directive, says that you write a purchase agreement, you get it. Obviously, our purchase agreement is written in such a way that you can put that we have it. It would be 0 days. We have it. Matter of fact, if I have 0 days and I already have it, I would put in additional conditions. We have it. I'd send it over with the offer to purchase. Frankly, it's a better offer. We already hold the earnest money deposit. Make sense? So it's going to depend a little bit upon. But as I'm going to say, as we move in, now this kind of market's kind of the same. We don't always get the offer accepted, right? So it's written in such a way that we'll get the deposit if we get an offer. Then we don't have to deal with the earnest money deposit with no offer on a property. Okay? So that's the way that we have that. We have ways to deposit with the title company. Yeah, and you can continue to deposit with the title company. And it just says, state law does not say 72 hours. It is 48 hours. Within 48 hours, and again, that's why I put it in writing, within 48 hours of receipt of acceptance from the sellers. So if you've heard 72, it's 48. Let's see. You know what, John? I forgot to bring that one up. So here's one for you. I get an offer accepted this coming Friday night. I have an earnest money deposit I've received in my hand. Is your office open on Saturday, Sunday, or Monday next week? It is not. Here's what they're saying. Immediately would be, it's there Monday or Tuesday morning and in the hands of the broker. Okay. And should it say business days? Well, you could say business days if you want, but it's not necessarily business days because it is under the terms of what Michigan state law and the code actually give us. So we're okay. We're okay. All right, let me continue on. I don't know. All right, so how is EMD applied? Here's what we know. When we close the deal, it's going toward the total amount of money they need that day for closing. So if they gave me 5,000, they needed 10,000, they only doing 5,000 a day of closing. We'll just keep it simple for that part of it. Here's the part where if you want to keep your financial staff happy and love you, if you ever have an overage, don't request the overage the day of the closing. That is a major, major pain. It's a huge rush. It disrupts their flow. You know, who do I got to get it to? And I don't know if anybody wants to drive to Lapeer. And Lapeer agents, that doesn't mean you guys get a break. So if you have an overage, anticipate that in advance. Give yourself in your digital calendar a reminder to request an overage. Okay? Well, why would I even have an overage? I want to make a really, really good looking offer. Okay? Could be I've got a lot that I'm buying for $75,000 and I'm paying cash and I wanted to make sure that they take my $75,000 on a $100,000 asking price. Here's the whole $75,000. And so there's lots of reasons we might have that overage. Keep that in mind. If the EMD we're holding exceeds the amount, we got to ask for that overage. I don't think there's any issues for that. So then we have default. And this is where, again, I hope that you never have to run into it, but it happens. People do silly things, both buyers and sellers. So if the buyer, here's what we know. Theoretically, notice the word, the EMD will be forfeited and given to the seller from the broker's trust account. And typically it's spelled out in the PA. So just that easy, it goes to the seller, right? Oh, no, no, no. No, it does not. What about when a seller defaults? Theoretically, the EMD gets returned to the buyer. And the buyer may choose to seek legal action. It's called specific performance. Perform specifically to the terms of the purchase agreement. Could a seller sue a buyer for specific performance? That's really a mouthful. The answer is yes. But if there was financing involved, yeah, good luck. By the time they could actually get the money, they could go buy a car. There's lots of things that they could do. So here's what we really need to know. This is from our purchase agreement. And this is where we need to read and know what it says. So you've always kind of went by the default. Well, you should know what it says. In the event that the buyers fail to fulfill obligations set forth herein or fails to close this transaction in the time and manner provided, sellers may elect to enforce the terms hereof. They could declare the sale void. and retain the earnest money deposit as liquidated damages, or seek all available legal and equitable remedies. So if you've ever thought that, well, you just forfeit it, oh no, there's more that could happen. They probably won't take the earnest money deposit if they're going to take additional legal action, because they're anticipating getting more than whatever the earnest money deposit was. So whenever you're consulting, what's the biggest thing that we do when we start talking legal terms with buyers or sellers? I am not, okay, you guys had it hanging there right on the tip of the tongue. I had to make sure it was right there. I am not an attorney. And that is a key phrase that we all need to know. I am not an attorney, but let me read what this says. Okay? Here's what it says for a seller. In the event the seller fails to fulfill obligations set forth hereunder, fails to close its transaction time and manner provided, buyers may elect to enforce the terms herein. Declare the sale void, be entitled to refund of the earnest money deposit, and or seek available legal or equitable remedies. Can you sue a seller for specific performance as a buyer? Yes. Now, it could be very costly, but it can be done. Would there be a situation where the broker receives the EMD and if either one defaults? Our purchase agreement, I believe, states that we will we would be able to keep 50% of any money that either, well, if we were representing the buyer, no, let me rephrase that. If the seller were to default, there's nothing, basically. We'd have to go after our commissions. But if the buyer were to default, we're representing the seller. Our listing contract says that we are able to keep up to 50%, I believe it's 50%, of the earnest money deposit. Now, that's one where you're going to talk to your broker, manager, and decide what we're really going to do. Do we still have the listing? We may just say, no, you take that. You're the one who was harmed. We'll sell the property. We'll get it sold. But every situation is different in regard to that. Everybody good there? I'm looking at the faces. I think we're good. All right. So why do we need a mutual release? Well, you have a binding agreement. And that binding agreement said you either lived up to the terms of the agreement, it got applied, or you were in default of the purchase agreement and you forfeited it. But it goes beyond what the purchase agreement said, because you see, if we could just go, oh, well, you defaulted, the purchase agreement says, then that makes everything easy. Well, here's what it does. It really directs how the EMD is to be dispersed. It makes it real clear that any party that could have any claim to that, they've all signed off as to how it would be dispersed. So it says, 1, buyer, I release you. 2, seller, I release you. And here's how we're handling the earnest money deposit. That fully executed mutual release lives up to the terms of what the purchase agreement said. But what if the seller said, no, I want their earnest money? Well, here's the key. This is what we need to understand. The brokerage cannot hold any EMD unless there is a dispute, in which case the broker cannot release the earnest money because there is a dispute. So we can't hold it just because, but we can't release it if. What's the only way that we really know there's no dispute? A mutual release. So we need something that says there's no dispute. Because if we have something that shows there's no dispute, we cannot hold it. But if there is a dispute, we cannot release it, and we cannot be the judge in it. And hear me on this. Yeah, but the purchase agreement says it doesn't matter. We're not the judge. There is a dispute. Oh, well. Is it they just won't sign it? Different story. But then we have to take different measures. But what we need to know is why we have it, how it can be disputed, what we can do if it is disputed, and what we cannot do if it's not disputed. And at the same point, if there is no dispute. But we have to have verification there's no dispute. All right? All of those, obviously, I'm going to talk with my broker manager. Now, what if we can't get them to settle and we have to take court actions? Otherwise, we can't get the buyer and seller to agree on how it should be handled. Does it happen? It does happen, okay? Normally, we're able to get it. I can tell you I've never had to take the step of court action, which is an interplead is the term. Never been involved in it, even from the level that I've been with the company for the last 10 years. Not familiar with it. We've been able to do the things to be able to get that, okay, we couldn't get a mutual release and the seller disappeared. Well, they didn't give us a dispute. We released, but we've got verification that we've done everything we could to verify there is no dispute. But if it takes the court, the broker can actually take it to the court and ask the court to make a legal determination as to how this should be handled. But here's the fun part. We can collect all the fees necessary to be able to have that action taken. So remember when I said that $1,000 should be the bare minimum? There's a reason for that. Let's make it worthwhile. Because if this, and by the way, notice I put it in bold and underlined, as low as, it could be more. So if you got 1,000, what's left over for anybody? Otherwise, come on, don't force me to do this. There's not going to be many money left over. How do you want to get this handled? The buyer and seller should come to an agreement with us. Well, what if there's more? Okay, well, I'm not an attorney. But if you two fight over it, what are you going to have to do? Legal representation. How much do attorneys not set fees at? 1/3, right? But it's not set. Yeah, I'm going back to the settlement. Yeah, read into that one, you'll get it. But they don't set that, but they all charge that, okay? Well, there went 1/3 of the earnest money deposit. What's your time worth, Mr. and Mrs. Seller or Mr. and Mrs. Buyer? Come to an agreement. And as agents, look, if you can get them to agree, take whatever you can get. That's my guidance. That's been my experience over 35 years, 38 years this year. Small claims, if it's 6,500, 6,500 or under, small claims. But even then, how much is it going to cost? Because they could avoid legal representation. I haven't checked out the cost of small claims court. Something you got to do. So let me actually go back with this. Not bad. What questions do we have, guys? Because there had to be something that came up, your experience that you've run into, where you're going, well, I had this. So it's Q&A time. Open up, just bring it out. What do you got? I always do this. Seven seconds, nobody's got any questions. So then with that, I'm going to say thank you for hanging out with me today. I wasn't sure how many people would actually come out. I saw 40 on with us at one point, but I'm going to throw out these reminders. We always record as long as Darwin remembers to start the recording. It's always recorded and put on the HRC Agent Development channel on YouTube. So you're going, well, yeah, but I can't ever, just HRC Agent Development channel. It's going to come up on the top of the search list. Okay. All recordings are there. as long as we don't do anything that violates their policies, like telling somebody's addresses and phone numbers and things of that nature. It'll always be there. The other reminder, we've got nothing for next week. It's the day after Labor Day, so Memorial Day. I always want to turn the two. So it's the day after Memorial Day. A lot of people will extend that weekend out, or they go that weekend and they take the week off. And I say, awesome, especially if you earned it and deserve it. Do that. And then let me just check. I see how long, what a typical civil action. Ooh, good question on that one, Holly. I've not had one, but I think it's about how long does it take for it to get to the court? And again, it's just like, is it worth it? And the reason I've always said, I'm not an attorney, but my advice, get what you can. Dean, can seller resell home without mutual release if deposit being disputed? I'm going to say, Dean, in most situations, the answer is yes. And the reason being is we need something that says clearly that the buyer is not buying the house. I'm going to say if it's 10 days past when we were supposed to close, they've fallen off the face of the earth. We have something in writing that says that they're not selling or they're not buying. Seller can put that home back on the market. Now, you may have trouble with the title company, because title companies will say we need a mutual release because there could come a claim from that. But one of the best real estate attorneys that I know has informed me that yes, once we know that that buyer has stated and shown that they're not going to buy, there's only a dispute in regards to earnest money deposit. And I think that's really the key. And obviously, Dean, with that one, you're going to want to get the broker managers involved with that. So if refund is needed, the check must have been deposited for 10 days before HRC. Yeah, so it's got to run its course. So if they give us a personal check, it's got to clear. So even if it's certified funds, you know, people can take a picture of it, deposit it, and now it's no longer any good. So you think it's certified funds. No, still got to make sure we get paid, right? Jason, you got that quick question there, buddy?
So let's say offer is accepted. We deposit the check, it goes through, but during the inspection, something happens and the deal falls apart. And we already cashed their check. And let's say they're actively seeking a house. Can the buyer agree to keep that money in escrow with us so that on the next house it's already there, or do we have to like refund them after that specific transaction?
We can absolutely continue to hold that in our escrow account. It's what I would recommend. As a matter of fact, I just closed one last week, Tuesday, with that exact situation. Had an agreement on a house, did the inspection, went, holy cow, we don't want this, got the mutual release signed, left the money in our account, found another house, got an agreement all the way through. We closed on Tuesday. It just simply moved over to the new property on that
Cool.
new PA.
Thank you.
Yep. Great question, buddy. All right. Well, guys, I think that's it. So I'm going to say for me, we'll call it have a great day, a great 2 weeks, because we're not going to see you in a couple of weeks, or we won't see you next week. And then, guys, do me a favor, because I am not managing an office any longer. So this is what I get to do between me and my own business. It's only when questions come to me that I'm kind of realizing what's going on in the marketplace. So if you run into things, send me, I don't care, send me the questions, call me on the questions, say, hey, Darwin, here's one that's just recently come up. Throw me those things, because it's how I keep a pulse on what's going on and why we call it Hot Topic Tuesday. I'm rarely more than a week in advance of a topic. It's 2 or 3 at most. So keep those coming to me. So again, guys, enjoy the Memorial Day weekend. If you're not, keep working, but you know what to do. Go talk to people, and we'll see you in 2 weeks. Have a great one, guys.